This is file number 255079. The record should reflect Mr. Heinz is present here in the courtroom today. I'd like to have counsel put your points on.
Trying to say on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Heinz.
All right, thank you. This is the date and time set for sentencing in this matter. And Mr. Heinz, have you had an adequate opportunity to go through the pre-sentence report? Do you have enough time to talk to Mr. Travis about that? Travis, are there any additions, deletions, or corrections to the report?
Yes, Your Honor, just some minor ones that Mr. Heinz noted. On the last 2 pages, basic information report, it indicates in the middle, under where it goes height, weight, highest grade, occupation, and it says assets up to $1,500, and it says no, and it says monthly income up to $75, and it says no. I think both of those, given what's stated in the rest of the report, are not accurate. He does own a pickup truck and he is employed and does, as noted, make a wage.
Okay, so those should both indicate yes.
Yes,
Any
Your Honor.
objection to that, Mr. Ziegler?
No, Your Honor.
Mr. Travis, any other corrections?
No, Your Honor.
I noted one because on that same page, under adult history, it indicates 0 jail, 0 prison, 0 probation, but it does appear based on criminal justice section, the adult history, that he has been on probation a couple times prior. So
That is correct.
looking at,
There's
Yeah.
at least 2 prior probations indicated. 3.
Ms. Wagner, do you count deferral probations in that?
Yes, I would probably, we can make it change to 3.
Okay. But I don't think any prior jail sentences, is that correct?
Correct. I didn't see any jail.
Okay. All right, so we'll correct the adult section to reflect 3 times on probation. Okay. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this morning?
No, Your Honor. Or this is Mr. Chairman, Your Honor.
Oh, that's right. Okay. Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, this is a tough one for me. On the one hand, I am somewhat sympathetic to some of the things the defense is no doubt going to tell you about this case. Rose Berge and Matthew Wiesner are not model citizens. Ms. Berge is currently being charged with stealing Mr. Heinz's checkbook around this time, passing forged checks. Mr. Wiesner, when asked whether he attacked Mr. Heinz at the prelim, pled the fifth. This is certainly not a clear-cut case. However, I think the evidence is clear that the defendant escalated this situation in a way that significantly endangered both Ms. Berge and Mr. Wiesner. And regardless of their own issues, they do not deserve to be threatened with a deadly weapon. I cannot accept the idea that this was somehow a valid use of self-defense. It sort of strains credulity in my mind to claim self-defense while using a bow and arrow. He would have to have gone and gotten the bow, put the arrow in the bow, drawn the bow. Perhaps there's a circumstance where you could make that argument, but to me it seems a stretch. If he was being assaulted or threatened or whatever the case may be under these circumstances, he should have done what Ms. Berge and Mr. Wiesner did in this case, which is leave the situation and call law enforcement and have them sort out any issues. He did not do so in this case. His criminal history is minimal, but as the court has already noted, he's been under court supervision 3 times in the past. It's also troubling to me that his prior offenses involved alcohol issues, involved resisting police, and involved possessing a weapon under the influence. The fact that he's been on probation for offenses involving weapons and assaults in the past suggests to me that probation was insufficient for him to learn that lesson. So I think the recommendation contained in the PSI does make a lot of sense, Your Honor. A 30-day sentence is a reasonable outcome. It balances the goals of punishment, deterrence, and rehabilitation. Hopefully the defendant will realize after serving some time in jail that it is not a place that he needs or wishes to be. and that he needs to make better choices, not just with, using alcohol, using weapons, but in who he allows into his home in the first place to put himself in that situation. I would ask the court simply to adopt the recommendation contained in the report.
Thank you, Mr. Travis.
Thank you, Your Honor. And Your Honor, Mr. Heinz comes here having pled somewhat because of the things Mr. Ziegler indicated, one because of the offer, but we discussed basically the self-defense, and I often talk to clients about what self-defense really means. And it's not a justified, it's not a they started it. And in talking to Mr. Heinz, he had the insight to say, yeah, no, I probably didn't have a self-defense. It doesn't mean in that moment he didn't feel that what he was doing, is what he needed to do. Because we talked about the nature of, you need to be actively being assaulted generally to have a successful self-defense. It can't be that he had threatened me earlier, we were arguing, it was escalating. Now, on the flip side, this all happened in his home. The victim here was someone that they had a history with. It's very complicated, but Mrs. Berge is a friend and someone that Mr. Heinz knew. Because of her bad, volatile relationship with the victim here, she was staying with Mr. Heinz. Mr. Wiesner was not an invited guest. He'd been told numerous times he wasn't welcome. So he wakes up in the morning, thinks he's just going to find his phone, finds Mr. Wiesner there. They get into it. Mr. Heinz believes that they had been using drugs and acting weird. As noted, Mr. Wiesner, that when I asked him about any violence or threats he'd made to Mr. Heinz, he pled the fifth. He wouldn't talk about that, which he's pretty savvy to the criminal justice system. So I would take that to imply that he did do something to Mr. Heinz. So we're here, he pled because he realized that his defense ultimately probably wasn't going to work. And he didn't claim self-defense and he entered this plea. But as Mr. Ziegler acknowledges, and I think maybe even the plea acknowledges, this was not a clear-cut, clean situation. He was in his own home with a hostile person inside his home, who he had numerous times previously told was not supposed to be in his home. So maybe he acknowledges he overreacted, but he's accepting that. And that's in the light of, a calm, rational view of it, not, waking up in the morning and finding someone who's not supposed to be in your home threatening you. So, Your Honor, I realize the recommendation is not for probation. Mr. Heinz and I have talked about this. He'd be more than willing to do probation. I understand that, a jail recommendation is not unreasonable, but I think the fact that he pled, he's accepting that, yeah, and in retrospect, I should have handled it better. We could have had a trial. Honestly, the odds of the two of them showing up were very mixed. They have extensive criminal histories. So he is taking responsibility, Your Honor. And I think that is very important here, given the nature of the situation. Thank you.
All right, thank you, Mr. Heinz. Anything that you wanted to say today?
Just that what he said was right. That I probably didn't handle it the best that I should have. But I was placed in a hard situation, and like you said, I was trying to find my phone. They had taken my phone, so I couldn't call the police when I wanted to. And I did end up going over to my neighbors and using the phone to call the police.
I did read through the report. I'm familiar with the circumstances in the incident that happened based on the information in that report. And yeah, I mean, certainly, I think there was some provocation here on the part of the other two individuals that resulted in you doing what you did. And I can certainly understand being in your own home, having somebody there that you've told not to be there, who's trespassing, who's threatening you. You want to take some kind of action to protect yourself, to protect your property, and to get that person out of your home. And that's not unreasonable at all. What is, I think, under these circumstances unreasonable is you getting a deadly weapon to do that. once you do that, that changes the whole landscape of what's going on. And it puts you in a position where you certainly aren't justified under those circumstances in using a deadly weapon, but you've got one in your hands. If any kind of mistake happens, you're not here on an assault charge, you're here on an attempted murder or a murder charge. And I don't think that's the way you wanted it to go. But once you grab a weapon, you need to understand that you're changing the whole landscape of what's happening in that circumstance. And if you're going to do that, you need to understand when and how you can have a weapon in your hands and when it's justified. And I don't think you understood that at the time. And so I think what makes this an offense that's justified with a short jail sentence is that weapon aspect of it here. I think that needs to be a deterrent for you so that you understand that that's not appropriate under these circumstances, and a deterrent for the community so that people generally know that being threatened, having somebody in your house that you don't want there is one thing. Getting a deadly weapon to remove them on your own is something completely different. So I think the recommendation is well crafted. The court can sentence you to up to a year in jail for this. I don't think that's anywhere near appropriate under all the circumstances, but I do think a 30-day jail sentence accomplishes those goals of punishment and deterrence. So the court is going to follow that recommendation and sentence you to the Kalkaska County Jail for 30 days with credit for 2 days served, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $50 state cost. This is a misdemeanor, so there are no written appellate rights. If you wanted to appeal this sentence, you would need to do that within the next 21 days. If you have any questions about that, Mr. Travis would be able to help you with that. Other than that, you are remanded to the custody of the county at this time.